Namaskar, Dilip Singh Advocate. Welcome to my channel Legal Outlook by Dilip Singh. On 5th June 2020, central government announced three ordinances related to agricultural reform under Article 123 of Constitution of India. We all know that Article 123 of Constitution of India empowers the President of India to promulgate or put in force ordinances to deal with the urgent situation when Parliament is not in session. It is difficult to understand in the present scenario what kind of urgency was there for the government which initiated these ordinances in the timing of lockdown. Ordinances in general criticized for being undemocratic in nature, and particularly this kind of ordinances were bound to get the due criticism. And Punjab government on 28th of August 2020 moved a resolution and which was passed by the Punjab Assembly rejecting the centre's ordinance. And then the opposition planned to oppose these ordinances on 16th September 2020 when the monsoon session of Parliament was in session, and they plan to move a resolution against these three ordinances, but the government outwitted the opposition move, and on 14th of September 2020 they introduced all these three bills. Let us see what are the rival arguments of government and the opposition on the issues. Quite natural it is that the government will show all the praises for the bills and the effectiveness of the bill, whereas the opposition will engage in fault finding for these bills. But we have to see the matter objectively and particularly as a student of law. Before going further, let me tell you that there is under 7th schedule of Constitution, there are three lists. One is the union list, that is list 1, and other is the state list, that is list 2, and a third is the concurrent list. In union list, Parliament has power to legislate, and the state list, state legislature has the power to legislate, and in concurrent list, both have the power, but the act passed by the Parliament prevails over the state legislature. The question arises why the area of state legislature was taken by centre. Because we have to see the issue from the point of view of federal structure of the government, and all these three ordinances is directly related to the area of agriculture which comes in the list 2 of the state list, and particularly when this encroachment is against the spirit of federal structure enshrined in the Constitution. We all know that the federalism is the basic feature or basic structure of the Constitution. So it was criticized. The center had taken the stand for these three ordinances, that they are related to the trade and commerce in food items, and which is part of the concurrent list. So Parliament is competent to frame legislation, and so with that the act of the centre is within the constitutional propriety. One apprehensions which is agitating in the mind of the farmers, so they are agitating that this is the beginning of the process to end the minimum support price for procurement by the government. Other contentious issue in these three bills are involved is of Agriculture Product Market Committee Act passed by the various state legislatures. Government says that the present act will ensure that a farmer can sell their farm product outside the APMC, so they will get better price. This is the basic plank on which the government is actively defending this bill. So what in many states, let me tell you one thing, that there are many states where there is no APMC existing, and even if where they are existing, there are various amendments have been passed by the state legislatures during the course of time, and they are incorporating all the characteristics of the APMC of the present provisions which are incorporated in the present bill. For example, Bihar abolished APMC Act in 2006. Kerala, Manipur, Kerala and Manipur do not have any legislature like APMC, and still they are working well. Sikkim have this APMC but did not implement till today. Almost all states where APMC is working, state legislatures have amended several times, and they have allowed trading, private players, contract farming with way back. States like Andhra Pradesh, Arunachal Pradesh, Assam, Gujarat, Goa, Haryana, Himachal Pradesh, Karnataka, Maharashtra, Mizoram, Nagaland, Orissa, Rajasthan, Tripura, Punjab, Jharkhand, Uttar Pradesh, they all have APMC, and they have updated the system and which are working well in the present situation. So this was the argument given by this by the state governments or by the stating farmers and the other intellectuals. Interestingly, opposition wanted voting before at the time when it was introduced in Rajya Sabha, but deputy chairman passed with voice vote, and this is not befitting in the parliamentary norm. Let it be as happened. So let us see the act very objectively. The main act and the first act I would like to discuss with you is the Farmers Produce Trade and Commerce Promotion and Facilitation Bill 2020. From the point of view of central government, what is the rationale of the central government for enacting this new central act? The answer lies in the central government justifies that it had circulated the Model APMC Act 2003 and the Model Agricultural Produce and Livestock Marketing, Promotion and Facilitating Act 2017, but the state did not work to reform of the APMC in a uniform manner, and the step was this step was to increase the competitiveness in the agricultural supply chain, provided freedom to farmers to sell their produce. So under these circumstances, the center was put into the condition to bring this bill. As a student of law, it is very difficult to digest these reasons for encroaching the statute, encroaching the area of state. Why state only? What I find as a student of law, and having great respect for the Constitution of India, why not the Panchayati Raj? That too has a constitutional status after the 73rd Amendment in 1992 by Narasimha Rao government. He brought this amendment on the report of L.M. Singhvi report of 1986. Even the Panchayati Raj is the competent body to take care of the interest of farmers and the agricultural of their area. So this bill, the Farmers Produce Trade Bill, we have to see in the context that center's steps should have been to strengthen the Panchayati Raj. In this act, a new word has been introduced, that is the trade area. Now let us see the act. The trade area is introduced, and which includes place like farmyard, warehouse, cold storage, and deliberately this definition deliberately does not include, or it deliberately excludes any place like market yard managed by the APMC. So it is a process to come out of the APMC Act of State Legislature. It also facilitates electronic trading of scheduled farmers' produce. Now, any company, partnership firm, and registered society can establish and operate electronic trading. Section 3 of this Act gives freedom to farmers to trade interstate or intra-state trading outside the APMC field. Section 4 of the Act deals with the trader's eligibility And particularly subsection 3 of section 4 is very important because it makes compulsory for the trader to make payment of farmers produce on the same day or within 3 working day, maximum by 3 working day. So this is made to safeguard the interest of the farmers. Section 5 of this act says that any person other than individual having a PAN number may establish and operate an electronic trading and transaction platform for facilitating interstate or intrastate trade and commerce in the scheduled farmers produce in a trade area. How this act curtails the revenue of a state? Why this state are making hue and cry? Because section 6 of this act prohibits collection of any trade or cess on trade outside the APMC market area. This is again a curtail. This is a very serious issue for because it leads to the curtailment of revenue of a state. In an article I read that UP government even during this lockdown period in the July of this 2020 um, earned sales and to the tune of 160 crore in 1 month. So this is a huge revenue loss for the state government, and particularly in the situation when the state governments are already facing a lot of financial crisis and revenue crisis after GST. And so again a dependency on the center will be increasing for the state government. So what is the other question which comes to my mind, which what is an important step to develop networking of informations relating to farmers produce? Because this act has done one very good thing, that it has the provision under section 7 for creation of a central government organizations to develop a price information and market intelligence system. I'm particularly emphasizing this price information and market intelligence system for farmers produce, because the more and more informations are available to the farmers and the other traders and other stakeholders, it will go a long way in developing the interstate mechanism for development. As an advocate, we are particularly concerned with the dispute resolution mechanism, penal provision, as well as the exclusion of civil code in this act. So, what is the dispute resolution mechanism provided in this act? The first stage is the conciliation board, which is provided in the section 8 of this act, which deals with interstate dispute between the farmers and traders provided under section 4, and in this case parties may seek mutually acceptable solution through the conciliation by making application to SDM, who shall refer it to the conciliation board. And one conciliation board chairperson will be appointed by the SDM, and the other two members from the each party, they will recommend it. And if they fail to recommend within a period of 7 days, if any party fails to make a recommendation of the persons from his side within 7 days, then the subdivisional magistrate SDM will appoint from his side this two member of this conciliation board, whomsoever he thinks fit to represent that party. And the settlement arrived by this conciliation board will be binding on the parties. If any dispute is not settled within 30 days, then automatically it will be referred to the subdivisional authority and from there which will be the appeal subdivisional authority for the settlement of such a dispute, and he will decide this in a summary manner within 30 days. Now, any party aggrieved with the subdivisional authority may prefer appeal to the appellate authority within 30 days, and that appeal will be disposed again within 30 days from the date of filing of such appeal. So, any order passed by this subdivisional authority or the appellate authority will have the force of a decree of civil code and shall be enforceable. As such, the decretal amount shall be recovered like the land revenue. So this is the mechanism. Now section 9 of this act also provide a very effective body like the agriculture marketing advisor and they will be either appointed by the central government or by state government, and they will have the power to take cognizance if any party fails to adhere with the guidelines issued by the act or by the central government, or any breach in the procedures laid down by this act. And this will be, they will dispose of, after taking the cognizance, they will dispose of the complaint within 60 days from the date of receipt. Now, section 10 deals with the penalty. Section 10 deal with the penalty. Section 10 says about the appeal against the order of section 9 and 10. Sorry, it is again the provision of appeal, and that any appeal from section 9 will be disposed of within 90 days, and the period for filing the appeal will be also 90 days. Now the comes penalty section. It is provided in what are the penalties provided for traders or the electronic platforms operators if they are not dealing with the farmers in proper way. So section 11 deals with the punishment to the traders for violation of section 4 or the rule made thereunder, and the penalty will be, minimum penalty will be 25,000, and the maximum penalty can go up to the 5 lakhs rupees. And if the contravention or if the violation of the violation continues, then 5,000 per day for continuing contravention. Now, the another penalty provision is for violation of section 5 and section 7, and there the penalty provided is not less than 50,000 rupees, and it can go a maximum up to the 10,000 rupees, and another 10,000, sorry, 10 lakhs rupees, and rupees 10,000 per day for continuing contravention. And this penalty is for the electronic platform operators. Now, the important provision is section 13, which gives the central government or the state government or the officers of central or state government a protection from any initiation of any suit or complaint or any kind of proceeding, legal proceeding against them if they have done an act in the good faith. This is one provision which, according to me, which is again a bureaucratic approach, and this will increase the license Raj kind of thing in the government and the functioning of this various organs under this law. I think this is a retrogressive steps, and this will even give rise to the corruption. So, and the public participation, which ought to have been as it is in the case of APMC Act, will decrease. So, this will also provide space for officials to work against the interest of the farmers. So, this is what I feel that it should not have been in the here. The another provision which is very important and very far-reaching is the section 14, which provides that this act will have overriding effect vis-a-vis the state any act of APMC Act passed by any state legislature. So we can see that this sounds a death knell for the APMC Act, and gradually the APMC Act will wither away. The another important and very, very important section is section 15, which bars the jurisdiction of civil court. As an advocate, I have seen that wherever this kind of setup is created and the working of such organizations, it will not be in interest of the farmers, because they will be deprived remedy from the civil court, and all bureaucratic approach will prevail there. SDM, DM, they all will be having a bureaucratic control. So I am against this provision of section 15 where the civil court is barred, and the farmers are not given the provision for availing the benefit of civil court, because civil court is a place where the remedy seekers feel at ease and a judicial approach is taken. So what we see that the purpose of this act is to centralize everything related to agricultural and taking away from this area of Panchayati Raj system or the state government. So my take is agricultural related issue should go to and should be inclusive, and panchayati system should be actively and should be very um, should be ingrained in the panchayati raj system, so that the agricultural related product and its the benefit directly goes to the farmers. This is more a deal oriented legislation than delivery oriented legislation. Correct approach is strengthening of Panchayati Raj and giving them more power, giving them and training the persons there, so that the farmers who are in contact with them should get direct benefit and they should have a sense of participation in the entire process. Thanks for watching this video. Please like and share this video with your friends so that it can reach to the maximum persons. Please wish me good luck by subscribing to my channel. Thank you very much. Namaskar.